Two civilizations, two legal systems, imperial Rome, the foundation of civil order and the rule of law. A system designed to govern the world through human authority, using the structure of a republic. Standing in contrast to this system is the Torah, a teaching understood as divine inspiration. Stay with us to discover, today, the untold truth about Judeo-Christianity.
Shalom, shalom. Welcome to your channel, Law Mishnah TV. Today marks another week, another lesson. Thank you for studying with us. Today, we focus on the biblical portion known as Parashat Shoftim, found in the book of Deuteronomy, which translates from Hebrew as Judges and stands as one of the Torah section's richest in Hebrew jurisprudence. However, today we are going to step into a time machine to understand how our laws have evolved from ancient times to the present day. A process of evolution and syncretism that has shaped the world we live in now, with all its contradictions and problems. I am Abel Flores, a journalist, researcher, and the founder of Law Mishnah TV. I personally thank you for studying with us. Before we begin, I invite you to subscribe to the channel if you haven't already, hit the like button, and visit our website, lamishna.com, where you will find a wealth of content on all these topics. There is an idea that almost all of us have heard at some point, that Western justice was born in Rome, and it seems logical. When we speak of courts, contracts, property, obligations, citizenship, or legal procedures, the shadow of Rome is everywhere. Even our legal language continues to speak, often unknowingly, with a Latin accent. But this is where the problem begins. Because centuries before Justinian compiled Roman law, and even before the famous 12 tables appeared, the Torah, the law of Moses, was already raising a much more uncomfortable question. Who judges the judge? Who keeps the ruler in check? And what happens when the law is perfectly legal, yet deeply unjust? This week, we study Parashat Shoftim, which begins with an extraordinary phrase, Shoftim veshetrim titan lacha. You shall appoint judges and officials for yourself. And just a few verses later, one of the great legal manifestos of the Hebrew Bible appears. Tzedek, tzedek terdof. Justice, justice you shall pursue. It does not merely say to respect justice. It says to pursue it. And that distinction can completely transform our understanding of the law. For Rome developed an extraordinary system of legal engineering. It taught us how to organize people, property, obligations, contracts, legal actions, and procedures. Its influence on Western civilization is immense. Yet Shoftim proposes something different. The judge is subject to justice. The priest is subject to the Torah. The prophet can be challenged. And even the king must write a copy of the Torah, read it throughout his life, and remember that he is not above his brethren. Here, we see two giants of legal history face to face. Rome asks, in large measure, how do we build a legal system that actually works? The Torah introduces a different question. How do we prevent the person holding power from coming to believe that he himself is the law? In this class, we will delve precisely into that tension. We will discover what the West truly inherited from Roman law and what stems, directly or indirectly, from the biblical tradition. We will compare the 12 tables with the Torah, Roman ayus with halakha, the emperor with the king described in Deuteronomy, the Roman concept of ikitas with the biblical tzedek, as well as false testimony, judicial bribery, the proportionality of an eye for an eye, property rights, liability, and due process. But we will also dismantle a very popular myth. Did the Romans copy their laws from Moses? The historical answer is far more surprising than a simple yes or no. Similarities exist, some of them extraordinary, but similarity does not necessarily imply historical dependence. And that is precisely where serious inquiry begins. And there is something even more important. This class is not merely about Rome or ancient Israel. It is about us. For whenever a judge issues a ruling, a government enacts legislation, a majority claims power, an individual asserts their rights, or someone asks whether obeying the law is synonymous with doing justice, Rome and Jerusalem meet once again. By the end of this class, you will understand why the West can be described, to a large extent, as Roman in its legal grammar and biblical in part of its moral imagination. You will understand the origins of certain ideas we now take for granted and discover that many of them were not self-evident at all. But above all, I want us to leave with a much more personal question. When the Torah commands, "Justice, justice you shall pursue," is it speaking only to judges? Or is it saying that no society can be more just than the everyday decisions of the people who make it up? For perhaps the great discovery of Shoftim is this: civilization begins when we create laws, but justice begins when we accept that no one, absolutely no one, is above them. Before we begin this class, and following this brief introduction, I would like to remind you that both on our YouTube channel and on our website, lamishna.com, we offer a free course on the Mishnah, where you can study this entire body of ancient wisdom, from the first tractate to the last, in your own language. Don't miss this opportunity. Now, let's begin. Parashat Shoftim is not a legal code in the modern sense. It is something perhaps more ambitious, an architecture designed to prevent power from becoming the master of justice. The Torah mandates the appointment of judges and officials, forbids bribery and partiality, demands rigorous evidence, distinguishes between intentional and accidental homicide, regulates warfare, and establishes a central judicial authority. Yet it introduces an even more radical idea. Even the king is subject to a higher law. That is why Deuteronomy proclaims, "Tzedek, tzedek tirdof," justice, justice you shall pursue. Deuteronomy chapter 16, verse 20. Rome would follow a different path. From the 12 tables to Justinian, the Romans developed an extraordinary legal technology: property, possession, contracts, obligations, procedures, and categories for organizing people, things, and actions. Much of modern law still thinks using that Roman grammar. This raises a fascinating question. Did Rome derive these ideas from the Torah? Historically, we must be cautious. There is insufficient evidence to claim that the 12 tables were copied from Moses. We find striking similarities: the lex talionis, law of retaliation, the punishment for false testimony, the protection of boundaries, and the condemnation of judicial bribery. Yet, sharing a solution does not necessarily prove a shared origin. The truly interesting story unfolds later. Rome and Judaism came into direct contact. Roman law and halakha coexisted, debated, and in some instances interacted. By the 4th century, the collatio legum mosaicum et Romanorum had appeared, explicitly comparing Mosaic legislation with Roman norms. Later, the Bible, Christianity, Roman law, and canon law became a complex fusion that would play a decisive role in shaping the West. That is why our legal system in the Western world does not have a single father. It is Roman in much of its legal grammar, biblical and Christian in part of its moral imagination, and Romano-canonical in much of its procedure, and profoundly modern in its universal formulation of rights. And here, Shoftim offers a warning that remains extraordinarily relevant. Judge, priest, prophet, and king all possess authority, yet none holds absolute authority. That is perhaps one of the great secrets of the rule of law. A society begins to be truly free when even the ruler must answer to a system of justice that does not belong to them. Now, when we speak of Hebrew law, we must begin by correcting a very common misconception. We are not talking about a single book, a single code, or a single historical period. We are speaking of a legal tradition that developed over centuries. The first stratum is the written Torah. There we find the Book of the Covenant, spanning Exodus chapter 20 through 23. The priestly and holiness collections, especially Leviticus chapter 17 through 26, and of course the major legal body of Deuteronomy. Yet Judaism never understood that to be the end of the matter. The rabbinic tradition also speaks of the oral Torah, methods of interpretation, traditions, and rulings found in the Mishnah, the Tosefta, Halakhic Midrash, and the 2 Talmuds. Later, new stages emerge: Geonic literature, Maimonides' Mishneh Torah, the *Tur, the *Shulchan Aruch, glosses, responsa, customs, and contemporary rulings. Therefore, when we say Hebrew law, we must immediately ask, which era are we talking about? Jewish tradition asserts an extraordinary continuity of revelation. The Mishnah, in Avot 1-1, declares Moses received the Torah at Sinai and transmitted it. Historical critical research raises a different question. It examines how the collections of the Pentateuch were formed and edited throughout the first millennium BCE. These two perspectives must not be conflated. One belongs to the religious affirmation of continuity and authority. The other investigates historical, literary, and documentary processes. And here, a fundamental principle for our comparison with Rome comes into play. We cannot take an interpretation from the Babylonian Talmud, dating from several centuries later, and automatically project it onto Iron Age Israel. That would be like studying United States law by reading only a 21st century court ruling and assuming that George Washington thought exactly the same way. Now, there is a fundamental term, halakha. It stems from the Hebrew root halak, the root of the Hebrew verb to walk. In other words, halakha does not simply mean law. It is, literally, a normative way of walking through life. And that path encompasses religion, ethics, family, commerce, torts, judicial procedures, and community life. Our modern separation of law, morality, and religion is somewhat alien to this universe. The Torah combines narrative, commandment, ritual, principle, and case. The Talmud adds discussion, disagreement, interpretation, examples, and reasoning. Therefore, reducing this entire tradition to the word code would impoverish it. But take note, we need to exercise the exact same care when speaking of Rome. There was no single Roman law, either. There was ius civil, relating specifically to Roman citizens. Ius gentium, linked to solutions applicable to broader relations between peoples, and ius honorarium, developed by magistrates, especially the praetors. To this, we must add popular laws, senatorial decrees, the opinions of jurists, and, during the empire, constitutions issued by the emperor. Gaius, in his institutes, masterfully organizes the Roman legal universe into persons, things, and actions. And centuries later, Justinian would order a massive compilation, the Code, the Digest, the Institutes, and the Novels. But again, a word of caution. Justinian's compilation dates to the 6th century CE and contains materials accumulated over centuries. It is not an intact snapshot of Republican Rome. Comparing it directly to the Torah without accounting for more than 1,000 years of development would be historically perilous. That is why we need 3 levels of comparison. First, demonstrated influence. A verifiable historical channel exists. Second, possible contact. The communities coexisted and we find parallels, yet we cannot prove dependency. And third, functional analogy. 2 civilizations find similar solutions because they face similar human problems. This distinction is essential because there are 2 equally tempting errors. One consists of denying any biblical contribution to the West. The other approach involves finding a resemblance and immediately declaring, Rome copied Moses. Serious history does not work that way. And finally, we must abandon another modern fantasy, the belief that legal evolution always signifies progress. A society can develop extraordinarily sophisticated contracts while maintaining slavery. It can speak of justice while excluding women or foreigners. It can protect certain rights while denying others. Rome possessed legal greatness alongside profound inequalities. The Hebrew tradition produced extraordinary ideas of justice while also reflecting ancient social structures. And perhaps that is precisely the most important lesson. Studying ancient law is not about searching for perfect heroes. It is about discovering how real human beings attempted to build justice within imperfect societies. And that question, 2,000 or 3,000 years later, remains exactly our question. Before Rome, before the Shoftim, judges, and even before anyone imagined a law school, human beings already faced a rather familiar problem. Someone had to decide who was right. For written law did not invent justice. Long before the great legal codes, families, clans, temples, palaces, and cities resolved conflicts through custom, oaths, arbitration, compensation, political authority, and often vengeance. The Great Revolution arrived when those norms began to be written down. Writing made it possible to preserve decisions, train scribes, stabilize expectations, and, of course, legitimize the ruler. However, we must avoid anachronism. Those collections were not necessarily codes in the sense we understand them today. Contracts, judgments, edicts, and customs continued to operate alongside them. Mesopotamia offers us extraordinary examples. Uarnamu, Lipitishtar, Eshnunna, Hammurabi, and the Assyrian and Hittite laws. In the 18th century BCE, Hammurabi presented a sophisticated system of casuistic legislation. If a specific situation occurs, then a specific consequence follows. And here we find something fascinating. Hammurabi presents the king as the guarantor of justice, the protector of the weak, and the recipient of divine authority. Yet that justice does not operate the same way for everyone. The legal consequence may vary depending on the social standing of the victim or the person responsible. In Egypt, we encounter another extraordinary concept, Mot. Mot signifies truth, justice, balance, and cosmic order. We know of no Egyptian code comparable to Hammurabi's stele, yet there existed a complex judicial and administrative practice. This teaches us something fundamental. In the ancient world, religion, morality, politics, and law did not inhabit separate compartments. And then, the Torah appears. Here, we must be rigorous. Biblical legislation did not emerge in a cultural vacuum. It shares legal issues and forms with the ancient Near East, oxen causing damage, loans, deposits, slaves, bodily injuries, boundary markers, property, and witnesses. So, what makes the Torah unique? Precisely this. Its originality lies not necessarily in inventing every rule from scratch, but in reorganizing the legal universe around a different theological and moral vision. In the case of Hammurabi, the king receives divine authority and administers justice. In the Torah, the ultimate lawgiver is God, and the king himself is subject to a law he did not write. That difference is immense. Furthermore, memory becomes a legal argument. Why must you protect the stranger? The Torah answers, because you know the soul of the stranger. You, too, were a stranger in Egypt. Historical experience is transformed into moral obligation. Moreover, worship and social justice become linked. A fraudulent scale is also a religious issue. The rest of the worker and the slave matters. Debt matters. The poor matter. The stranger matters. The court matters. Everything is part of the same responsibility before God. Yet, we must not romanticize the past. The Torah belongs to an ancient society. We find patriarchy, slavery, corporal punishment, and legal distinctions between groups. Leviticus 25 permits the permanent enslavement of foreigners, while other texts limit Hebrew servitude, protect the injured slave, and severely condemn kidnapping. Intellectual honesty requires holding both realities in view simultaneously. And then comes Greece. The polis developed public laws, magistrates, citizen juries, an extraordinary reflection on justice, nature, and convention. Plato, Aristotle, and later Stoicism provided categories that would reach Roman thought. Cicero would speak of natural law and of right reason linked to nature. That is why we must abandon an overly simplistic view of history. There was no straight line stating. Mesopotamia created the law, Israel received it, and Rome copied it. Reality was far more interesting. There were cultural networks connecting Mesopotamia, Egypt, Israel, the Aegean world, the Phoenicians, Persians, Greeks, Hellenistic peoples, and, finally, Rome. Ideas, institutions, and legal solutions circulated for centuries. And here arises the question we should keep in mind for our class. If all these peoples had laws, courts, and punishments, what truly distinguishes the Shoftim? Perhaps it is not simply a matter of having laws. Perhaps their revolution lies in something far more dangerous for any ruler, establishing that even the one who holds power must submit to a justice that stands above him. There is an idea in Parashat Shoftim that is extraordinarily modern. Even though it dates back more than 3,000 years, the issue is not merely who holds power, but who places limits on the person holding that power. Shoftim begins with these words, "You shall appoint judges and officials, police, for yourself." Deuteronomy 16, verse 18. Shoftim are judges. Shotorim are officials charged with organizing and carrying out administration. In fact, in modern Hebrew, Shotorim translates as police officers. And here, the first revolution emerges. The Torah does not entrust justice simply to the goodness of individuals. It institutionalizes it. We need judges, jurisdictions, procedures, and authorities capable of enforcing decisions. For a society that relies solely on the goodness of its rulers faces a problem. One day, it will have a ruler who is not so good. That is why the Torah forbids perverting justice, favoring someone based on their identity or status, and accepting bribes. It also offers a profound psychological insight. For a bribe blinds the eyes of the wise. Deuteronomy chapter 16, verse 19. Let us note something here. It does not say that a bribe blinds only the corrupt person. It says it can blind even the wise. The Torah understands that intelligence and morality do not immunize us against our own self-interest. So it proclaims, Tzedek, tzedek tirdof. Justice, justice you shall pursue. Deuteronomy chapter 16, verse 20. Why repeat the word justice twice? Sifrei Devarim 144 links this command to the search for a competent court. Other commentators find an extraordinary idea here. It is not enough to achieve a just outcome, we must also achieve it through just means. In other words, the end does not sanctify the process. Subsequently, Deuteronomy chapter 17 establishes a central authority for cases too difficult for local courts to handle. But take note, that authority does not belong to the king. Legal interpretation is entrusted to the court, the Levitical priests, and the presiding judge. Later, rabbinic tradition would link this passage to the authority of the Great Sanhedrin. And this does not eliminate debate. Quite the opposite. The Mishnah and the Talmud are filled with disagreements. The genius lies in transforming disagreement into a procedure. Majorities, arguments, precedents, interpretation, and debate. A mature civilization does not require everyone to think alike. It needs to know what to do when intelligent people think differently. And then we come to the king. Here, Shoftim, asterisk, becomes politically explosive. Deuteronomy 17 permits the monarchy, but immediately begins to limit it. The king must not amass too many horses. He must not amass too many wives. He must not accumulate excessive silver and gold. He must write a copy of the Torah, read it constantly, and avoid letting his heart become haughty above his brothers. The message is extraordinary. The king governs, but the king does not own the law. Some scholars have seen here a sort of distant precursor to constitutionalism. We must be careful. This is not a modern democracy, nor is there a Supreme Court exercising judicial review. But there is a fundamental intuition. There is a norm that precedes and stands above the ruler. And here, the contrast with Rome is fascinating. The Digest conveys the Latin expression, princeps legibus salutis est. The prince is not bound by the laws. Asterisk Digest, January 3rd, 31. Its historical scope requires nuance, as we also find emperors praising voluntary submission to the law. But Deuteronomy goes further. The king does not submit out of generosity. He submits because he is obliged to do so. And asterisk Shoftim asterisk limits yet another extremely dangerous form of power, the power to claim that God speaks through oneself. Deuteronomy chapter 18 regulates the priest and the prophet, and prohibits divination, necromancy, and sorcery. Even the prophet must be examined. Spirituality grants no immunity from scrutiny. After all, the Torah requires 2 or 3 witnesses for serious convictions, distinguishes murder from manslaughter, and establishes cities of refuge. And it concludes with a disturbing scene. A corpse is found, and no one knows who committed the murder. The asterisk Egla Arufa asterisk ritual in Deuteronomy chapter 21 compels the nearest community to respond ritually to that death. Sotah 9-6 takes the question even further. Did we do everything necessary to ensure that person could continue their journey with food and protection? In other words, the fact that we do not know who killed someone does not mean society can wash its hands of the matter. And perhaps therein lies the great political architecture of Parashat Shoftim. It limits the judge. It limits the king. It scrutinizes the prophet. It regulates evidence. It protects the accused. And it holds the community accountable. For the true rule of law begins when we stop asking merely who holds authority and start asking, to whom is the person in authority accountable?
Two civilizations, two legal systems, imperial Rome, the foundation of civil order and the rule of law. A system designed to govern the world through human authority, using the structure of a republic. Standing in contrast to this system is the Torah, a teaching understood as divine inspiration. Stay with us to discover, today, the untold truth about Judeo-Christianity.
There is something extraordinary about the history of Jewish law. The writing of the Torah concludes, yet the legal conversation is only just beginning. For every legal text inevitably faces the same problem. Life generates cases that the text does not address in detail. The Torah commands the observance of Shabbat. Fine, but what exactly constitutes work? It mandates compensation for damages. How do we calculate the value of an injury? It requires witnesses. Who is eligible to testify, and under what conditions? Here begins the vast development of the oral Torah. Rabbinic tradition does not view itself as inventing legislation independent of the Torah, but rather as interpreting and applying a received revelation. To do so, it employs midrash, analogies, hermeneutic rules, gezerot, preventive decrees, takanot, ordinances designed to address new needs, minhag, custom, and judicial rulings. Around the year 200 CE, Rabbi Judah the Prince, Yehuda HaNasi, compiled the Mishnah, organized into 6 orders. Later came the Jerusalem and Babylonian Talmuds, preserving centuries of discussions, arguments, and disagreements. And this is fascinating. Judaism lost its political sovereignty, yet it did not lose its legal creativity. The literature of responsa enabled communities separated by thousands of miles to consult on new issues and receive rulings grounded in ancient principles. In the 12th century, Maimonides systematically organized halacha in his monumental Mishneh Torah. Later came the Arba'a Torim by Jacob ben Asher, the Shulchan Aruch by Yosef Karo, and the Ashkenazi glosses by Moses Israelis. Yet no codification succeeded in eliminating debate. Very Jewish indeed. Finally, we have the code, and now we can begin to argue about it. However, this evolution produced something far more profound than libraries. It created legal mechanisms designed to limit the irreversible consequences of human error. Let us consider capital punishment. The Torah prescribes the death penalty. However, the Mishnah establishes extraordinarily demanding procedural hurdles. Larger courts, rigorous interrogations, special majorities for conviction, and additional avenues for acquittal. Mishnah Sanhedrin 4-5 confronts witnesses with the immense responsibility of destroying a life. And Mishnah Makot 110 contains a striking discussion. A Sanhedrin that executed one person every 7 years was considered destructive. Rabbi Elazar ben Azariah says even one execution every 70 years. Rabbi Tarfon and Rabbi Akiva maintain that had they been part of the court, no one would have been executed. But Rabban Shimon ben Gamliel counters with an uncomfortable objection. Such a system could multiply murderers. Here we have a surprisingly contemporary debate. How do we protect the innocent without leaving society unprotected? We must not claim that capital punishment was never applied. That would be historically incorrect. What we can state is that rabbinic halacha raised the procedural barriers for a standard capital conviction to an extraordinary level. And then we arrive at the famous ayin tahat ayin, an eye for an eye. Many immediately picture a brutal scene. Someone has lost an eye, now we must tear out the culprit's eye. But the rabbinic tradition interprets the principle as financial compensation. Mishnah Bava Kama 8.1 establishes 5 categories: injury, pain, medical expenses, loss of work, and humiliation. The Talmud, in Bava Kama 83b to 84a, elaborates at length on why an eye for an eye translates legally into monetary payment. Interestingly, the Roman 12 tables also recognize lex talionis, retaliation, for certain injuries when no agreement is reached. But this does not prove that Rome copied Moses. The principle of equivalence appears in ancient Near Eastern cultures much earlier, and there remains an idea that is perhaps even more profound. For the Talmud, strictly adhering to the law does not always mean achieving the highest form of justice. Sanhedrin 6b discusses asterisk peshara, compromise or mediation, seeking a form of justice capable of also producing peace. And Bava Metzia 30b makes an extraordinary accusation. Jerusalem was destroyed because people clung exclusively to the strict letter of the law and failed to act asterisk lifnin mishurat hadin, literally beyond the line of the law. This does not mean ignoring the rules. It means understanding the difference between asking, what can I legally demand, and asking, what ought I to do morally? That is why the tradition combines din, law, mishpat, judgment, tzedek, justice, rachamim, mercy, and shalom, peace. And perhaps therein lies an essential lesson for our lives. The law establishes the minimum we can demand of ourselves. But a truly just society begins when we stop asking only what we are obligated to do and start asking what is the right thing to do. To understand how much we owe to Rome, we must begin with a paradox. The Roman law that transformed the West was not born finished. It took Rome almost 1,000 years to build it. One of its first great moments were the famous 12 tables, traditionally dated around 451 and 450 BC. They arose in the midst of the conflict between patricians and plebeians, and its importance was also political, making public a normative base that until then was strongly controlled by the elites and pontiffs. In other words, writing the law meant limiting, at least partially, the monopoly of those who claimed to know it. The original text of the 12 tables was lost. We know it through fragments and later references, so we must reconstruct it cautiously. It regulated debts, family, inheritances, property, damages, crimes, and procedures, and we should not idealize it. It was a harsh, formalistic, and deeply hierarchical law. It allowed extreme consequences for debts, recognized an enormous patria potestas, the authority of the father of the family, and contemplated retaliation. But we also find rules against judicial bribery, false testimony, and certain legislative privileges. The 12 tables were also not a complete and immutable code. Rome did something that, curiously, reminds us of rabbinic tradition. It retained reverence for an ancient text while developing mechanisms to interpret and adapt it. The similarity is fascinating, even if the institutions and sources of authority were completely different. During the Republic, the system becomes much more complex. We have laws, plebiscites, senatorial decisions, custom and legal interpretation. And a fundamental figure appears, the praetor. The praetor could grant actions and remedies through his edict. This is how the ius honorarium was developed, capable of helping, complementing, and even correcting the rigidities of the old ius civile. Here appears one of the great Roman geniuses. For Rome, it was not enough to say, I am right. The legal question was also, what action gives me the right to assert that reason? Because a hopeless right can simply become a beautiful statement. Roman expansion also created another problem. What do we do when Roman citizens negotiate and litigate with foreigners? From this environment, the us gentium developed, a set of solutions considered common or useful beyond the ancient exclusive right of the citizen. But be careful, it was not yet international law or modern human rights. Then we come to the classical era, when Rome produced some of the great jurists in history, Gaius, Papinian, Paulus, and Ulpian, among others. They refined property, possession, contracts, obligations, successions, and procedures. Gaius organizes law through an extraordinarily influential classification: people, things, and actions. And Oppiano formulates a memorable definition of justice. Justitia est constant and perpetual voluntas, jus suum quique tribuendi. Justice is the constant and perpetual will to give each person their right, and it summarizes three principles: honeste vivere, alterum non laedere, suum quique tribuere. Live honestly, do not harm others, and give each one his own. It sounds wonderfully universal, but here the contradiction appears. The same Roman law that pronounced these maxims legally divided humanity, as Gaius explains, between free and slaves. Rome forces us again to distinguish legal sophistication from moral equality. Then, with the empire, the center of gravity changes. The emperor accumulates power, and his constitutions acquire legal force. In the year 212, the Constitutio Antoniniana extended Roman citizenship to almost all free inhabitants of the empire. But universal citizenship among the free did not mean universal equality. Slavery, social hierarchies, and legal inequalities continued. With Constantine and the Christianization of the empire, something decisive happens. Rome does not abandon its right to simply adopt the Bible. Rather, a complex coexistence begins. Christianity modifies aspects related to religion, marriage, church, charity, and morality, while Roman structures of property, contracts, family, and procedure continue. And finally, we come to Justinian. Between 529 and 534, he ordered centuries of legal thought to be gathered into what we would later call corpus juris civilis: code, digest, institutions, and novels. Centuries later, especially from the 11th and 12th centuries, these texts will be intensively rediscovered in Europe, with Bologna as a great intellectual center. Romanists and canonists will build the jus communi, one of the fundamental matrices of European law. That's why Rome never completely disappeared. It survived in universities, courts, concepts, and codes. Every time we talk about property, possession, obligation, contracts, successions, or legal actions, we can still hear echoes of that ancient Roman conversation. And perhaps that is Rome's true legal greatness, not having created a perfect law, but having built a language so powerful that later civilizations could debate justice using its grammar for centuries. We now arrive at one of the most controversial questions of this class. Did Rome derive its law from the Torah? The temptation to answer yes is enormous. The similarities appear striking. The Torah requires laws to be publicly known. Rome developed the 12 tables. The Torah recognizes the principle of an eye for an eye. The 12 tables also provide for lex talionis, retaliation. Both traditions punish false testimony, protect property boundaries, regulate damage caused by animals, condemn judicial bribery, and contain rules regarding family and inheritance. It seems simple then to conclude, Rome copied Moses. But here we must do something fundamental: distinguish an appealing claim from a historically demonstrable one. For similarity does not necessarily imply dependence. To demonstrate that Rome systematically derived its law from the Torah, we would need to find a mechanism of transmission: Roman access to the biblical text, identifiable intermediaries, shared unique legal terminology, ancient testimonies acknowledging such dependence, or a documentary sequence difficult to explain in any other way. And for the 12 tables of the 5th century BCE, such evidence does not exist. Moreover, many of these legal issues are universal. Every agrarian society must decide what happens when an animal destroys another person's property. Every society with courts must confront the issue of false testimony. Every society with property needs to protect boundaries. And every society with judges eventually discovers, usually quite painfully, that bribery is a bad idea. More importantly still, some similar solutions appear as early as Mesopotamia, centuries before the 12 tables. And Roman tradition itself links the 12 tables to Greek models, even if the historical details of that account are also debated. That is why we must establish a fundamental rule for this entire investigation. Priority in time does not imply causation. The fact that a biblical rule predates a Roman rule does not prove that Rome adopted it from Israel. Therefore, the academically responsible conclusion is clear. No direct and systematic influence of the Torah on archaic Roman law has been proven. But here, the story changes. For centuries later, Rome and Judaism did indeed come into direct contact. With Roman expansion across the eastern Mediterranean, Jewish communities are found in Judea, Alexandria, Asia Minor, Italy, and many other regions. From the 1st century BCE onwards, Rome intervened directly in Judea. We are no longer speaking of two separate worlds. Roman authorities, local courts, Jewish communities, and halakhic norms began to coexist. Rabbinic literature reflects this complexity. For instance, the famous maxim attributed to Samuel appears, Dina de Malkuta Dina, the law of the kingdom is law. It is discussed in texts such as Nedarim 28a, Gittin 10b, and Bava Kama 113a. This does not mean that every government order is automatically moral or halakhically legitimate. Its scope is a matter of debate. However, it acknowledges the legal validity of certain norms issued by the sovereign power, particularly regarding taxation and property. Here, we do see genuine interaction. Scholars such as Catherine Hayes have studied potential points of contact between Roman and rabbinic law regarding citizenship, children, captives, arbitration, and witnesses. Yet, once again, we must avoid overstatement. Sometimes there is influence, sometimes resistance, sometimes adaptation, and sometimes two systems simply arrive at similar solutions. Then, an extraordinary document appears, the Collatio Legum Mosaicarum et Romanorum, also known as the Lex D. It was likely compiled in Italy during the 4th century. And what does it do? It places texts from Moses alongside Roman legal texts. It compares laws regarding homicide, bodily injury, adultery, incest, theft, false testimony, deposits, property boundaries, kidnapping, sorcery, and inheritance. It is almost like watching an ancient jurist perform the very same comparison that we are making today. Its authorship remains a subject of debate. For a long time, a Jewish author was proposed. Recent studies frequently consider a Christian author with legal training more likely. But the important point is this. The collatio demonstrates a comparison, not an origin. It shows that in the 4th century, someone sought to demonstrate compatibility between Moses and Rome. It does not prove that 1,000 years earlier, the drafters of the 12 tables had copied Moses. And finally, the great historical encounter takes place. As Christianity deeply permeates the structures of the empire, the Bible also enters into Roman legal discourse. Yet even here, Rome does not simply replace its law with the Torah. A synthesis emerges. The Bible, Christian interpretation, Greco-Roman philosophy, and Roman legal institutions begin to blend together. And we must add an uncomfortable caveat. Christianization does not mean automatically implies humanization. The Christian empire produced legislation inspired by new religious convictions, but also restrictions and coercion directed at pagans, heretics, and Jews. Real history is never as tidy as our legends. That is why the question, did Rome copy Moses, may be poorly phrased. The truly interesting question is, when, where, and through what channels did Jerusalem and Rome begin to influence, confront, and ultimately encounter one another? And when we ask that question, we discover something far more fascinating than a simple copy. We discover a legal conversation that would ultimately help build the West. We now arrive at a fundamental difference between Hebrew and Roman law, not merely what they command, but the source from which they believe the authority to command derives. In the Torah, the law arises from a covenant with God. The Decalogue does not begin simply by saying, "You shall not kill." It begins by declaring, Anochi Adonai Elohicha. I am Hashem your God, who brought you out of the land of Egypt. Exodus 20 verse 2. This is extraordinary. Legal obligation is linked, first and foremost, to an experience of liberation. And because the law precedes the ruler, it can also judge him. That is why the biblical prophets could confront the king, the judge, the priest, and the powerful. Isaiah, Amos, and Micah appeal to a justice that no human authority can alter simply because it finds it inconvenient. In Rome, we find a different structure. Legal authority derives from the people, the magistracies, custom, jurists, and, eventually, and to an increasing degree, the emperor. Rome also developed concepts such as ius natural, natural law, and equitas, equity. Cicero would even speak of right reason in accordance with nature. Yet Roman positive law remains fundamentally the product of human institutions. The second difference lies in the purpose. The Torah integrates justice, holiness, memory, and social responsibility. Leviticus 25, verse 23 declares that the land belongs, ultimately, to God. This means that even property rights have limits. Institutions emerge such as the remission of debts, the jubilee, tithes, gleaning for the needy, and obligations toward the poor and the stranger. We must not anachronistically transform them into a modern welfare state, but they express a powerful idea. Possessing something does not mean having absolute moral power over it. Rome displays a different kind of genius. It constructs an extraordinary framework for property, exchange, obligations, contracts, and legal remedies. Ulpian summarizes a memorable ideal, some quic tribuere, to give each person their due. But here an uncomfortable question arises. Who determines what is one's own? For Rome could proclaim that ideal while making legal distinctions between slave, citizen, and paterfamilias. Justice also depends on how we define the person. And finally, there is another fascinating difference. The Torah does not merely seek to regulate behavior. It also aims to shape character. It commands us not to hate, to love our neighbor, to love the stranger, to open our hand to the needy, and to remember constantly, you, too, were a slave. The Talmud takes this even further, speaking of moral obligations that may go beyond the strictly required minimum. Rome distinguishes more clearly between legal obligation and moral duty, although concepts such as bona fides, good faith, and equitas, equity, allow for the correction of certain rigidities. But beware of an overly convenient simplification. We cannot simply say, Israel had morality and Rome had technique. That would be false. Halakha possesses extraordinary technical sophistication, and Rome developed a profound philosophy of justice. The true difference lies in the center of gravity. Rome asks us, with great precision, how to organize a society legally. The Torah adds a disquieting question. For what purpose do we wish to organize it? For a society can have perfectly designed laws and yet remain profoundly unjust. And perhaps that is where the true discussion between Rome and Jerusalem begins. Not merely who possesses the law, but what kind of human being that law seeks to build. There is a question that any legal system must answer. To whom should the power to judge another human being be entrusted? The Torah's answer is demanding. Deuteronomy chapter 1, verses 13 to 17, calls for judges who are wise, discerning, and respected by the community. Exodus chapter 18, verse 21, adds further qualities. They must be capable, God-fearing, men of truth, and averse to dishonest gain. And *Shoftim* adds a fundamental obligation. *lo tateh mishpat. You shall not pervert justice. The judge must listen to the lowly and the great alike, refuse to be intimidated by anyone, and reject bribes. The concept is remarkably modern. The quality of justice depends in part on the human character of the person administering it. Rome faced the very same issue. The reconstructed 12 tables contain an extremely severe penalty for any judge or arbitrator who accepts money to decide a case. The parallel with Deuteronomy 16:19 is striking. Yet, once again, resemblance does not necessarily imply influence. Wherever judges exist, the possibility of corruption exists. It seems that certain human weaknesses are universal in nature. However, the Hebrew judge and the Roman magistrate operated in different ways. In *Shoftim, the judge applies a Torah that does not strictly separate religion, ethics, and civil law. Later, the *Beit Din, the rabbinical court, would combine legal knowledge, the evaluation of evidence, and the rendering of a verdict. Rome developed a different structure. In classical civil procedure, functions could be divided. First came the magistrate, who determined whether a legal cause of action existed and formulated the issue to be resolved. Then the asterisk iudex stepped in, a private judge charged with examining the facts and applying that formula. This is a fundamental difference. Rome understood with great clarity that having abstract legal rights is not enough. We also need a procedure that allows those rights to be transformed into an effective remedy. With the advent of the empire, the system changed. The imperial asterisk cognitio concentrates more functions in the hands of professional officials and creates a hierarchical administrative structure. And here, another interesting difference emerges. Deuteronomy 17 also establishes a higher authority. When a local court faces a matter that is too difficult, it must refer it to a central authority. But a word of caution, this does not mean a modern Supreme Court existed. We do not find a general right of appeal as we understand it today. Instead, we find an institution designed to resolve difficult cases and maintain a degree of interpretive consistency. Rabbinic tradition would later develop courts with varying jurisdictions, courts of 3 judges, courts of 23, and the Great Court of 71, as described in Mishnah Sanhedrin 1. Imperial Rome, by contrast, progressively developed mechanisms for appealing from lower to higher authorities, and in certain circumstances, all the way to the emperor. This fostered legal uniformity. Yet it also contained a paradox. The more centralized the justice system became, the more deeply integrated it was into the imperial bureaucracy. And this brings us to the present day. Our modern systems feature lower courts, appeals processes, supreme courts, courts of taxation, and in some countries, constitutional review. Does all of this stem from Rome? No. Does it all come from the Torah? Not entirely. Our system is the product of centuries of combinations and transformations. Yet asterisk Shoftim leaves us with a question that no regal evolution has managed to render obsolete. How do we ensure that the person with the power to judge does not end up using justice as an instrument of power? For a court may possess magnificent laws, but if the judge fears the powerful, favors the wealthy, or is open to bribery, justice has already been lost before the trial even begins.
2 civilizations, 2 legal systems, imperial Rome, the foundation of civil order and the rule of law. A system designed to govern the world through human authority, using the structure of a republic. Standing in contrast to this system is the Torah, a teaching understood as divine inspiration. Stay with us to discover, today, the untold truth about Judeo-Christianity.
Let us imagine that someone accuses us of a serious crime. There are no cameras, DNA evidence, or forensic analyses. There are no phones tracking our movements. Our life might hinge on a single thing, another person's word. Precisely for this reason, the Torah places extraordinary emphasis on the nature of testimony. Lo yakum edajad beish. A single witness shall not rise up against a person. 2 or 3 witnesses are required for a conviction. And in capital cases, Deuteronomy 17 verse 7 establishes something even more unsettling. The witnesses must be the first to participate in the execution. Why? Because making an accusation ceases to be a detached act. Anyone providing testimony that could take a life must personally bear the immense weight of their words. The Torah introduces yet another safeguard. If someone conspires to secure a conviction through false testimony, they may face the very consequence they intended to inflict upon the innocent, as outlined in Deuteronomy 19 verses 16 to 21. Rabbinic tradition further elaborates on these safeguards. Avat 1:9 recommends questioning witnesses carefully while simultaneously being mindful of one's own questions, so as not to inadvertently teach them how to fabricate a lie. The Mishnah, specifically Sanhedrin chapters 4 and 5, establishes significant distinctions between civil, financial, proceedings, and capital cases. A fascinating principle emerges. When a life is at stake, the procedure becomes deliberately more cautious. Rome developed a different model. Throughout its history, we find no equivalent general rule mandating the presence of 2 witnesses in every instance. The evaluation of evidence could depend on testimony, documents, oaths, procedural rules, social status, and judicial discretion. Much later, a famous maxim would appear: testis unis, testis nullus, 1 witness, no witness. However, this rule became firmly established primarily within the later Romano-canonical tradition. We cannot simply claim that Rome adopted it from Deuteronomy. Nevertheless, Rome contributed another decisive principle to our legal tradition. The digest preserves a rule attributed to the jurist Paul, "Ei incumbit probatio cadicit, non conegit." The burden of proof lies with the one who asserts, not the one who denies. Digest March 2nd, 22. Here we find one of the historical roots of the concept of onus probandi, the burden of proof. Simply put, if you accuse me, it should not be up to me to prove that your accusation is false. You must provide evidence. Does this mean Rome invented our modern presumption of innocence? No. Did Deuteronomy invent it? No, either. The Torah requires investigation and multiple witnesses, placing, in practice, an enormous weight on the prosecution. Yet, it does not formulate our presumption of innocence in modern constitutional terms. The contemporary guarantee is the result of a much longer history: Roman law, the canon law tradition, common law, liberal thought, and modern constitutionalism. And here we must face an uncomfortable truth. Neither Rome nor historical halakha can be fully equated with our current standards. Both traditions restricted, in different ways, who could be considered a competent witness. Classical halakha established exclusions based on categories that would conflict with modern legal equality today. Rome was even harsher in certain respects. Credibility could depend on social status, and slaves could be interrogated under torture. Imperial law even went so far as to legally regulate that practice. This shatters a very common romanticized image. Rome gave us fundamental tools of legal procedure, but Rome did not single-handedly invent the modern fair trial. Nor can we project our current rights directly onto biblical or rabbinic society. Modernity inherited elements from both traditions, but also had to correct them and, in some respects, break away from them. Today, we champion procedural equality, the prohibition of torture, much broader witness eligibility, and the presumption of innocence. Yet, Shoftim leaves us with a warning that remains extraordinarily relevant. An accusation is not proof. A suspicion is not a conviction. And repeating a story 1,000 times does not make it true, either. For a truly just society does not demonstrate its greatness when it punishes the guilty. It demonstrates it when it establishes procedures capable of preventing the innocent from being treated as guilty. There is a vast difference between killing and murder. This seems obvious to us, but legally, that distinction changed history. It is not enough to ask what happened. We must also ask what the person intended to do, what they could have foreseen, and under what circumstances they acted. The Torah already distinguishes between these situations. Exodus chapter 21 and Deuteronomy chapter 19 differentiate between an accidental death and a homicide committed out of hatred, with intent, or via ambush. Numbers 35 adds elements such as the instrument used, the prior relationship, and the conduct of the accused. And a fascinating institution emerges: the city of refuge. It was not a modern prison. It combined asylum, protection, exile, and an expiatory dimension. Its function included protecting the unintentional killer from the blood avenger while the case was being legally adjudicated. Here, a crucial idea appears. Two people can bring about exactly the same result, the death of another human being, and yet not bear the same level of responsibility. Rome would develop this issue with extraordinary sophistication through concepts such as dolus, malicious intent, culpa, negligence, and various analyses regarding causality and liability. The lex aquilia, for example, became a cornerstone in the Roman development of liability for damages. This Roman classification would leave a much more direct mark on our modern civil law. But there is another important transformation. In ancient societies, the boundary between public crime and private harm was not always clearly defined. An assault could trigger family vengeance, financial compensation, or intervention by the authorities. The Torah attempts to limit blood vengeance through courts and cities of refuge, and regarding intentional homicide, it establishes a firm rule: money cannot be accepted as a substitute for liability for having deliberately taken a life, according to Numbers chapter 35, verse 31. Rome too evolved. In its early stages, it retained mechanisms for compensation and self-help. Later, it progressively distinguished between crimina publica, crimes prosecuted on behalf of the community or imperial power, and delicta privata, which gave rise to private lawsuits. Our modern system goes much further. The state assumes a monopoly over a large part of criminal prosecution, and distinguishes between punishing a crime and compensating for harm. We now arrive at what is likely one of the most famous and most misunderstood biblical expressions, ayin tahat ayin, an eye for an eye. Today, it is often cited as a symbol of primitive, vengeful justice. Yet, historically, it can also be understood in exactly the opposite way, as a limit on vengeance. If someone destroyed an eye, you could not destroy their entire family. The response had to be proportionate to the harm caused. And as we have seen, rabbinic halakha would interpret bodily injuries in terms of detailed financial compensation. Interestingly, the Roman 12 tables also provided for lex talionis, retaliation, in cases of certain injuries where no agreement could be reached. In both worlds, then, we find a fundamental transition, from limitless vengeance to an institutional and proportionate response. But our modern concept of proportionality goes much further. Today, we discuss necessity, the individualization of sentencing, the prohibition of cruel punishments, and the balance between the gravity of the offense and the sanction. And finally, we reach the most difficult topic, the death penalty. Both the Torah and Rome permitted it. Rome employed different methods depending on the crime and social status: beheading, crucifixion, burning, exposure to wild beasts, and other forms of execution. Even in death, social hierarchy could determine how one died. The Torah also prescribes capital punishment. However, the rabbinic tradition developed such stringent procedural requirements that they radically curtailed its routine judicial application. And here arises a tension we have yet to resolve. What should justice protect first? Society from the offender, or the accused from a potential error by society? For an execution possesses a terrifying legal characteristic. It allows for no appeal once a mistake has been made. That is why simply invoking Judeo-Christian values is insufficient to resolve the contemporary debate over capital punishment. Within the Jewish and Christian traditions themselves, we find arguments regarding retribution, mercy, prevention, human dignity, and judicial fallibility. And perhaps this is the major evolution we ought to observe. Justice began by attempting to limit vengeance. It then sought to determine intent. Next, it developed procedures to establish guilt. And finally, it had to confront an even deeper question. Not merely how much punishment the wrongdoer deserves, but how much power we are willing to entrust to fallible human beings to inflict that punishment. We now arrive at an uncomfortable yet fundamental question. When Rome and the Torah speak of the human being, are they truly speaking of the same kind of person? Genesis begins with an extraordinary statement, B'Tselem Elohim. The human being was created in the image of God. Genesis 1 verses 26 to 27. Genesis 9 links this image to the value of human life, and Mishnah Sanhedrin 4:5 develops a powerful reflection on the value of a single life and the common origin of humanity. Centuries later, these ideas would fuel discourses on human dignity. But we must avoid anachronism. The Torah does not yet contain our universal declaration of human rights. Rome starts from a different place. Gaius opens his law of persons with a strikingly direct classification. Human beings are either free or enslaved. The Roman person does not yet signify the universal individual endowed with equal rights. It signifies, to a large extent, a legal status defined by freedom, citizenship, and family. And here, another fascinating comparison arises: the foreigner. In certain areas, the Torah mandates the same law for the native and the foreigner. And Leviticus 19 verse 34 goes even further. V'ahavta lo kamoja, you shall love him as yourself. The reason? For you were foreigners in the land of Egypt. The memory of having been vulnerable transforms into an obligation toward the vulnerable. But again, we must add nuance. The Torah also distinguishes between the Israelite the resident alien, and other peoples. We are not yet dealing with modern universal citizenship. Initially, Rome reserves the ius civil for its citizens. Foreigners, the peregrini, operate under different legal frameworks and through the development of the ius gentium. Over time, Rome expands citizenship dramatically. In the year 212, the Constitutio Antoniniana grants it to almost all free inhabitants of the empire. The key word is free, for both ancient systems accepted slavery. And this must be stated clearly. The Torah protects the slave in certain respects. It mandates Sabbath rest, penalizes kidnapping, regulates Hebrew servitude, and provides for manumission in cases of injury. Yet, Leviticus 25 verses 44 to 46 permits the acquisition and inheritance of foreign slaves. Rome, for its part, built a vast portion of its economy and legal system upon slavery. This gives rise to an extraordinary intellectual contradiction. Roman jurists could acknowledge that, by nature, human beings are born free while simultaneously accepting slavery as a legal reality. A society may hold an extraordinary moral principle without carrying it to its ultimate conclusion. Modern abolition required centuries of further political, religious, philosophical, and social struggle. We must also recall an uncomfortable fact. While abolitionists used the Bible to fight slavery, defenders of slavery cited biblical texts as well. Moral history is not a triumphal march. A similar situation exists regarding the family. Both Rome and biblical society were patriarchal. The famous Roman patria potestas granted the paterfamilias extraordinary authority over his descendants and estate. The Torah also reflects asymmetrical family structures, yet it establishes limits. Deuteronomy prevents a father from arbitrarily manipulating the rights of the firstborn. Numbers 27 recognizes the right of daughters to inherit in the absence of sons. Meanwhile, Rome developed sophisticated institutions regarding adoption, guardianship, dowries, marriage, divorce, and succession, institutions that would directly influence later civil codes. Finally, we come to the concept of property. Here, the Roman legacy is immense. Dominium, possession, easements, usufruct, sale, lease, partnership, mandate, succession. Much of modern private law still speaks in the grammar of Rome. The Torah places the emphasis elsewhere. It, too, regulates property, loans, deposits, wages, and land, but it insists on placing moral limits on economic power. Do not withhold wages. Do not take as collateral what a person needs to survive. Return the cloak by nightfall. Leave part of the harvest for the vulnerable. Open your hand to the poor. Here, perhaps, we find one of the great syntheses that the West would eventually inherit. Rome provides us with a formidable technique for asking, what belongs to me, and what can I demand? The biblical tradition introduces another question. What responsibility do I bear precisely because something belongs to me? And perhaps a truly just society needs both. It needs clear property rights, but it also needs to remember that having a right to something does not mean being absolved of all responsibility toward others. There is a question that runs through all political history. Who controls the one who controls the others? Shoftim offers an answer that is surprising for the ancient world. The king in Deuteronomy is not portrayed as a being superior to the people. He is called, essentially, their brother. He holds authority, yet remains subject to a Torah that he did not write and cannot alter to suit his own convenience. In imperial Rome, we see a different direction. The emperor would eventually become the central source of laws, the highest administrative authority, and the supreme judge, even though jurists and later theologians insisted that a good ruler ought to respect the law. Of course, historical reality was more complex. Israel had despotic kings, and Rome produced significant ideals regarding limited magistracies. Yet Shoftim contains something extraordinary. It distributes authority. We have the judge, the priest, the king, and the prophet. It is not yet Montesquieu's separation of powers. God remains the sovereign, and functions overlap, but no single human being fully concentrates all sources of authority. The court interprets, the priest teaches, the king governs, and the prophet can look the king in the eye and tell him, "You are wrong." That is politically explosive, for it means that possessing power does not automatically mean possessing the truth, and this limitation applies even in war. Deuteronomy chapter 20 regulates military exemptions, proclamations, peace offers in specific conflicts, and even the protection of fruit trees. From this would later emerge the principle known as Bal Tashit, do not destroy unnecessarily. But we must also confront the difficult text. Deuteronomy chapter 20, verses 16 to 18, contains orders for destruction regarding the Canaanite peoples. We cannot turn an ancient ideology of conquest into an automatic authorization for contemporary warfare. Rabbinic tradition historically limited its application, and Maimonides later developed legal categories of war and conditions regarding offers of peace in Hilkot Melachim, chapter 6. Rome also developed the concept of bellum justum, just war, through Roman religious traditions and thinkers such as Cicero. Yet, as is often the case with empires, just war theory and imperial expansion did not always go hand in hand. Centuries later, Christian thought on war would combine the ideas of Cicero, Augustine, canonists, and scholastics with biblical sources. But *Shoftim* adds yet another extraordinary dimension: public responsibility. Deuteronomy chapter 21 presents the strange ritual of the *Eglah Arufa, the heifer with the broken neck. A corpse is discovered. The killer is unknown. Case closed? Quite the opposite. The death becomes a matter for the local community. Elders and priests must publicly answer for that bloodshed. The message is powerful. Not knowing the culprit does not absolve the institution of responsibility. We would not replicate that ritual today. Its moral equivalent would be to properly investigate a death, preserve evidence, support the victims, and ask ourselves if institutions failed. Rome also contributed to transforming certain private harms into offenses against public order, and the modern state went even further. It assumed a monopoly on criminal prosecution and added obligations linked to human rights. Yet *Shoftim* leaves an uncomfortable warning for any government. It is not enough for the state to claim a legitimate monopoly on the use of force. It must also assume the monopoly on the responsibility that accompanies that force. For when innocent blood is shed, a truly just authority does not merely ask, who was the culprit? It must also ask, what did we do to prevent it, investigate it, and ensure justice? We now arrive at the point where the similarities between the Torah and Rome become so intriguing that they can be misleading. For finding two similar laws does not automatically prove that one civilization copied the other. First similarity: the law must be known. Deuteronomy 31 mandates a periodic public reading of the Torah, and Deuteronomy chapter 17 even requires the king to possess a copy and study it. The 12 tables represent something similar in Rome, removing a normative foundation from the monopoly of the elites and making it publicly known. The coincidence is significant, but it demonstrates a common function of writing, not necessarily direct influence. Second similarity: bribery. Deuteronomy chapter 16, verse 19 declares that a bribe blinds the eyes of the wise. The 12 tables also severely condemn a judge who accepts money to render a decision. The parallel is extraordinary, but it likely reveals something less romantic. Where judges exist, corruption exists. And where corruption exists, sooner or later a law appears attempting to combat it. Third similarity: the famous lex talionis, ayin tachat ayin, eye for an eye. We find principles of equivalence in the Torah, in Hammurabi, and in the 12 tables. Hammurabi in particular demonstrates why we must be cautious. Rome did not necessarily receive the principle directly from Israel. Furthermore, the traditions evolved differently. Rabbinic halakha interpreted injuries in terms of detailed monetary compensation. In the 12 tables, the lex talionis could apply when no agreement was reached. Fourth similarity: false testimony. Deuteronomy chapter 19 establishes that a malicious witness may suffer the very fate they intended to bring upon the accused. Rome also severely punished false testimony. Centuries later, The asterisk collatio legum mosaicarum et Romanorum asterisk would place Mosaic and Roman laws side by side. This demonstrates that in late antiquity, someone clearly perceived their similarities. But take note, it demonstrates a comparison made in the 4th century, not a dependency dating back to the 5th century BCE. We also find parallels regarding property. Deuteronomy chapter 19 verse 14 forbids moving boundary markers. Rome regulated boundaries and property disputes. This is hardly surprising. 2 neighboring farmers could very quickly discover why humanity needed lawyers. And another fascinating example appears: dangerous animals. Exodus chapter 21 distinguishes between an ox that had never shown signs of danger and one whose owner knew beforehand that it was aggressive. The legal question is extraordinarily modern. Did you know a risk existed, and what did you do to prevent it? Rome also developed legal actions for damages caused by animals and forms of noxal liability. Once again, we find similar problems but different legal techniques. And finally, we arrive at a deeper point of convergence. Both traditions discovered that mechanically applying a rule does not always yield justice. The Hebrew tradition speaks of tzedek, of what is right and good, and of asterisk lifnin mishurat hadin, asterisk acting beyond the strict minimum of the law. Rome developed concepts such as equitas, equity, bona fides, good faith, and reflections on natural law. Yet these concepts are not identical either. In the Torah, justice is fundamentally rooted in the covenant with God. In the Greco-Roman tradition, we find nature, reason, utility, and civic tradition. And here is the golden rule for comparing Rome and Jerusalem. A resemblance may demonstrate affinity. It may suggest contact. It may invite us to investigate. But it does not in itself prove historical lineage. For 2 civilizations can arrive at similar answers without having copied one another. Perhaps because, before being Romans or Israelites, they all had to solve the exact same problem: how to build justice with human beings who are extraordinarily capable of producing injustice. Given the many similarities between Rome and the Torah, we must ask a fundamental question. Where do the major differences lie? The first lies in the very origin of legal authority. In the Hebrew tradition, the Torah is understood as divinely revealed. The law originates with God and must subsequently be interpreted by human beings. Thus, halacha can evolve through interpretation, precedent, gezerot, rabbinic decrees, takanot, enactments, and new applications, all while conceptually maintaining its link to Sinai. Rome operates differently. Law can emerge from the people, magistrates, custom, jurists, and ultimately the emperor. Rome can openly promulgate a new lex or a new constitution because it formally recognizes human sources of legal creation. The second difference lies in the scope the law seeks to cover. The Torah regulates food, worship, purity, agriculture, family, property, justice, and social relations as parts of a single life lived before God. To the biblical mindset, the question, is this religious or legal, would often have seemed artificial. Rome, too, had a concept of sacred law, yet its great contribution was the progressive development of extraordinary technical specialization, particularly in private law. Professional jurists analyzed property, possession, contracts, obligations, and legal actions with a precision that enabled something fundamental: the survival of that legal technique even when the society's religion changed. That is why Roman law could subsequently be adopted by Christian societies, and centuries later, by secular states. The third difference lies in the economic center of gravity. The Torah constantly insists on obligations toward the poor, the widow, the orphan, the Levite, and the stranger. This does not mean Israel had a modern welfare state. It means that property and wealth are subject to responsibilities derived from the covenant. Rome also had practices of charity, patronage, public distributions, and social legislation. But the heart of its legal legacy is far more closely tied to property, obligations, contracts, and status. Rome extraordinarily refined the question, what is mine? The Torah further insists, what must I do with that which is mine? The fourth difference lies in political power. Deuteronomy 17 places the king under a law he did not create. The ruler must read it and ensure that his heart does not become haughty above his brothers. In the late Roman Empire, a different shift occurs. The imperial will progressively becomes a central source of law. Thus, two impulses emerge that the West would inherit for centuries: the ruler subject to a higher law, and conversely, the sovereign as the creator of legislation. And finally, there was the matter of judicial evidence. Rabbinic halakha develops particularly strict requirements regarding testimony, especially when a life is at stake. Rome employs a more diverse evidentiary framework: witnesses, documents, oaths, presumptions, and confessions. Yet it also incorporated practices we now consider deeply unjust: torture and an assessment of credibility conditioned by social status. Centuries later, the Romano-canonical tradition would transform many of these elements, and modernity would transform them further, eventually leading to our current models of judicial evidence. So what is the fundamental difference between Rome and Jerusalem? It is not that one possessed justice while the other did not. It is not that one had morality while the other relied solely on technicalities. The difference lies in their center of gravity. Rome built an extraordinary science for the legal organization of society. The Torah constructed a normative order in which politics, economics, worship, and private life alike had to answer to a higher covenant. And the West would ultimately inherit elements of both tensions. We need Rome's legal precision, but *Shoftim* reminds us of something no technique alone can guarantee. We can build a perfectly legal system, and yet still be compelled to ask whether that system is truly just. That's all for today's class. See you in the next video. Shalom.